I'd like to call the meeting to order, and we'll begin with our land acknowledgement. And I'm going to ask Councillor Yurig to read it.
Thank you, Your Worship. We would like to begin by acknowledging that we are meeting on the traditional lands and treaty territory of the Saugeen Ojibwe Nation, which includes the Chippewas of Nawash Unceded First Nation and the Chippewas of Saugeen First Nation. We also recognize the Métis whose ancestors shared this land and these waters. We extend our gratitude to all Anishinaabe and Métis people and their descendants past, present, and future who continue to care for and inhabit these lands and tend these waters.
Thank you, Councillor Yurig. And I'd invite you now to join me in a moment of silent reflection. Thank you. Is there any disclosure of pecuniary interest and the general nature thereof? And seeing none, I just remind you that you can declare that at any time that it occurs to you. So I'd like to welcome everyone to tonight's meeting. We're here to learn about two site-specific proposals to amend the land use planning permissions applying to certain lands in the municipality of Meaford. It is very important for me to note that the Planning Act requires that a person who may later wish to file an appeal to Council's decision on any of these matters must either provide verbal comments today at this public meeting or provide written comments to Council before the amendments are passed. The intention of this requirement is that only those people who have taken the time and the care to learn about the proposal and to engage in the planning process may have an opportunity to appeal a decision to the Ontario Land Tribunal. While Council is legally required to make decisions that conform to the county and local official plans, our guiding policies encourage us to reach out to you, members of the community, to hear your thoughts about the proposed changes. We have a variety of legal tools available to us that we can apply to development to help us ensure that new uses can coexist with existing uses with as minimal an impact as possible. Your constructive comments will help us to learn more about your neighborhood, which in turn will help staff and Council to select the right tools to manage change effectively and in a manner that honors our community values and priorities. Those who have pre-registered for today's meetings will have an opportunity to speak remotely or in person. You do not have to be solely in support or opposition. It is okay to share your thoughts about those elements that you do and don't like about the proposal, and to ask questions as well. While the applicant will have an opportunity to respond to questions and comments at the end of the meeting, in some cases we may need to have staff carry out research on the matters raised and provide answers or additional information to you following the meeting. So I will now call today's first public meeting to order. This is a public meeting of the Council to consider an amendment to zoning bylaw 2009-60 for lands known as 0651994 Side Road. This meeting is a mandatory part of the planning process, which has been set out by the Planning Act. Based on the rules of the Act, there must be at least 20 days' notice given to residents within 120 meters of the property. Notice of the zoning bylaw amendment was issued on November 15, 2022, giving the required 20 days notice. So let's get started. First, I will ask Denise McCarl, Manager of Planning Services, to share a brief description of the application and to provide us with any public and agency comments that have been received to date. Denise?
Thank you, Your Worship. So I will be providing just a brief overview of the application and then summarize the comments after that. The applicant's land use planner, Liz Buckton, is here to speak to the application in more detail, and so I'll let her do that in a few moments. So this application was brought forward as to satisfy a condition of consent application B14-2022. And that severance application requested to sever a 6.26 hectare lot with an existing dwelling and garage located on 4 Side Road. And then the retained lot would be vacant in approximately 14.23 hectares. That application was what we call provisionally approved. So it was approved by the Committee of Adjustment with conditions. And one of those conditions was this zoning amendment. And so the lands are currently zoned Rural Exception 78 or RU-78 and environmental protection. There's no change proposed to the environmental protection or the EP area. And from what we can see, Exception 78 was applied through a zoning amendment 13-97, so in 1997, to allow a required front yard of 12 meters. So basically a 12-meter setback from the road for an accessory building, which we understand was a garage. This application then requests to rezone a portion of the lands, so the retained lands, to remove the Exception 78, since they are a vacant, that setback doesn't necessarily apply to these lands, and to apply a holding symbol to the lands to restrict development on that west side of the property. The holding symbol would apply 150-meter setback from the neighbor's property to the west, and Ms. Buckton will probably provide some more details about the holding symbol. However, I can explain that the purpose was generally to satisfy a concern from the neighboring property owner on the west side about future siting for a chicken barn. So those lands are agricultural on the west side and have existing livestock facilities. And we understood that that neighbor was planning to put a chicken barn in place and had some concerns that if someone down the road, if the severance went through, that they could build a house close to that side of the property and impact the ability for them to site that barn. So livestock operations must be set back specific distances depending on the type from a house. Likewise, a house has to be set back from livestock facilities depending on the facility itself. That's what we call minimum distance separation. So in this case, a settlement was reached between the neighbor and the applicant that they would, to satisfy the concerns, that this holding symbol would be applied, since a rezoning was necessary anyways as part of the consent. So this was a settlement that they reached together and then proposed that as part of an amended application to the Committee of Adjustment. And then one of the other factors was to leave this hold on for at least 7 years to allow that development of the barn to happen. If it doesn't happen, then that could be removed after that time. So the lands are designated rural and environmental protection in Meaford's official plan. And agency comments were received from the historic Saugeen Métis with no objection or opposition to the zoning application. The Grey Sauble Conservation Authority also had no concerns with the application and noted that the application itself does not propose any new development. Grey County also had no concerns with the application. Saugeen Ojibwe Nation had asked for clarification on the purpose of the application and then provided no additional comments. They were satisfied with that information. And there were no comments received from the public. And that's all I've prepared at this time.
Okay, thank you, Ms. McCarl. I understand the applicant's planner is in attendance, so I'll now call upon Liz Buckton to explain the proposal in more detail.
Great. Thank you very much, Your Worship, and hello to members of council. So I am here today. I've had the pleasure of working with Bud and Fran Falls over the past year as they've navigated the application process for the severance, as Denise has mentioned. We did work through a settlement with the neighboring property owner regarding the chicken barn. And so the zoning amendment application that has been made and the draft bylaw that was submitted alongside that reflects that negotiation between the landowners to ensure that that chicken barn can be placed as intended by the neighbor. We felt that being the rural area, agricultural operations are an important consideration. And so we didn't feel that it would be appropriate for us to continue without having addressed that concern, being that they were in process towards that barn. The Falls don't intend to build in that area of the property. So their intention is, if there is a dwelling at some point in the future, they expect it would be likely located on the hill so that it would be able to take advantage of the view of the valley as well. So that would be removed. But we felt that it was appropriate to put that holding provision in place because it would alleviate that concern of the neighbor in terms of them moving forward with their plans and then a house being constructed right next door to them that could veto what they were trying to do. So we felt that that was a good route to move forward on. I do believe that perhaps we'll hear also from the planner that was working on behalf of the adjacent landowner as well. I think that she will be entertaining some comments here as well, just to confirm the approach. Generally, I think within the application, and as Denise has outlined, we feel that the zoning amendment is appropriate. It does implement the conditional approval of the Committee of Adjustment, and generally is consistent with the PPS and upholds the policy direction of the official plans, both at the local and county level. And so we feel that it should be approved, and certainly I'm available to answer any questions that council may have with respect to that proposal.
Thank you very much.
Thank you.
There's been one pre-registration for virtual attendance at this meeting by a member of the public. And Ms. Sajarda, you now have an opportunity to speak. They're not here. Okay, well, thanks. Ms. McCarroll.
Thank you, Your Worship. So I understand that Julia she was having trouble with the link, so we've just resent her the information. So if it's possible to just give a few moments for her to connect.
Okay. Okay. Maybe we just give her 30 seconds here, and if it doesn't, if she doesn't get through, maybe we'll move on to our council discussion and then come back to her. That might be the best we can do. Okay. Members of council, questions, comments, Councillor Bartley.
Thank you, Mayor Kentner. A comment first, neither application today shows the severed parcels. That would be really nice to have that. Neither one of them shows where the lines are going to be drawn. I would like that. Having said that, on this thing, you're giving them 150 yards MDS. Is that enough?
There you, Your Worship. So I can't say that it's enough specifically. I, as a courtesy to the neighbor, did run an MDS calculation prior to the decision, and it looked like it would be more than fine to be able to have that extra space. I can't recall off the top of my head what the MDS reciprocal amount would be. So in this case, I ran it as though someone was putting a barn in, not that someone was putting a dwelling in place, and used the site plan that the neighbor had provided to me, as well as all of because there had been an MDS calculation done as part of the severance as well. So what I did was take all that information along with the proposed chicken barn and ran an MDS2 calculation. I didn't see any issue with that. However, I'm sure that Ms. Buckton probably can provide more details about why the 150 meters was chosen. We have to remember too that this is basically a hypothetical barn at this point. So I use the kind of the parameters that I was given by the neighbor. But if, for example, they do apply for an application for a barn, 150 meters doesn't seem like an unreasonable setback. And remembering too that they'd also have a setback from the property line in addition that they would be required to do, and through the road. But I don't have the number off the top of my head. I'm sure Ms. Buckton probably has a rationale about why the 150 specifically. But I can say that usually for an MDS2 that would be sufficient to a dwelling. Often that would be enough. Like 160 is a typical number that I see. There are different on every single one, just because it depends on the size of the barn, the type of animals in there, and the type of manure storage that they've proposed.
As I would think that a chicken barn might not be as, much of a concern as a pig barn, for example. Did you want to ask Ms. Buckton from her thoughts on that, or?
If Ms. Buckton could give me clarification, I know the property, I've been there, whatnot. I didn't think 150 yards was enough.
Thank you very much, through your worship. Happy to respond to that. So I think in this case, my understanding is that they're looking at an operation of 200 to 300 chickens to begin with, and perhaps an expansion, once they're up and running. And so I think where that ends up, you're correct, Mr. Mayor, that the setbacks do differ based on the livestock type. And so part of what goes into that calculation is the livestock type. So how smelly is their manure? And then how is it typically stored? And so there's those factors about the manure storage component and how much odor is produced go into that calculation in the back end. In this case, I think that falls in under kind of the threshold of 5 nutrient units, and that's kind of the cap below which we round up all of our calculations to 5 nutrient units in the software. And so I think that there is additional capacity built in to the calculation, because say if at 300 nutrient units, perhaps they're at maybe 3.5 nutrient units, I think is what it works out to. We've rounded up for a setback for 5 because that's the minimum within the calculation. And I would say based on the calculation that we ran for 300 chickens, including a yard setback for the barn, I'd calculated that out at about 120 meters, and they'd come back with 150. And so we went with the 150 just to err on the side of caution. So as far as I understand, it should be adequate for what they're proposing based on the nutrient units involved with that. But there is some additional leeway because we do have the 150 meters on the property setback, plus then an additional 15-meter setback required for the barn away from the side yard. Wonderful.
We now have Ms. Sajarda available, so perhaps we'll move on and hear from her. Thank you. Go ahead, Mrs. Sajarda.
Hi, everyone. Can you hear me okay?
Yes, we can. Thank you.
Okay, perfect. Thank you. We're just having some technical difficulties. So I represent through Meaford LLP, we represent the adjacent property owner, and I just wanted to express our support for the application with the MDS setback. And thank you, Liz, for giving a presentation explaining how we came here. And I think that's everything. I'm just I had notes, but after trying to connect, I'm just glad I got on, and everything is, I think, working okay now. So thank you, everyone.
Thank you very much. Are there other council inquiries or discussion? Seeing none, I just want to be doubly sure. I don't believe there is anyone in the audience who wishes to speak. But okay, that's fine. Then, are there any points raised that our development services team would like to respond to, Denise?
Thank you, Your Worship. Just Councillor Bartley's comment about the severance sketch and those sorts of details. Often on these small applications, we don't provide any drawings. I think it's just the way that zoning works versus a severance application, for example, which would include the site sketch. It also often they don't transpose very well into the notice, so they tend to be difficult to see. So, but it's a great comment, just because we've noted that there isn't a lot to see in these meetings when we're talking. So one of the things that I'm going to propose perhaps down the road will be probably, let's say for the next meeting, would be for us to, as staff, to provide maybe like a 4-slide presentation that just shows like the aerial photo, the sketch of what they're proposing, and just the facts of the application. And I think that that's worked really well in other public meetings that we've done, especially where there aren't presentations by applicants' teams. So in a bigger application, they may have a whole team of people, they've prepared a whole presentation, but on smaller ones, people don't tend to have gone to that level. And it means that we don't have anything to look at while we're chatting. So I think that that would help if that's something that council thinks would be helpful. I'd be happy to do that.
On behalf of council, I can say it definitely would be appreciated, and thank you very much. It'd be a great initiative. So now I'll ask the applicant to share their closing remarks. Ms. Buckton.
Thank you very much. So I do think through negotiation with the neighbor, we were able to resolve the concern, which did result in the Committee of Adjustment conditionally approving the application. I think we see this rezoning as more or less more technical, I guess, in nature, to both remove that unnecessary historic zoning provision on the lands and to establish the holding provision for the neighbors' benefit as well. So we would ask for your approval of the application. We do feel that it meets all of the planning tests that would generally apply to it. Like I say, if there are any last questions, happy to address those. But otherwise, I'll just leave it there.
Thank you very much.
Thank you very much.
And thank everyone for attending this meeting and sharing your thoughts on this application. This matter will now be referred back to Development Services staff to follow up on any additional information required from the applicant based on the matters raised today. And once staff is satisfied that they have all necessary information needed to provide a recommendation on the application, a detailed planning report will be brought back to council to assist us in our decision making. This report will evaluate how the proposal does or does not satisfy the provincial, county, and municipal policies that must be considered as part of the council's decision. It will also explore the various public and agency comments received regarding the application, noting these tools which may be applied in order to address concerns raised and to mitigate potential impacts on nearby properties. If you would like to receive mailed notice of a future decision on this file, please provide your contact information to the Planning Services Division by email at planning@meaford.ca. And I'll now call today's second public meeting to order. This is a public meeting of the Council of the Municipality of Meaford to consider a proposed zoning bylaw amendment for lands known as 123312 Storybook Park Road. This meeting is a mandatory part of the planning process, which has been set out by the Planning Act. Based on the rules in the Act, there must be at least 20 days notice given to residents within 120 meters of the property. Notice of the zoning bylaw amendment was issued on November 15th, 2022, giving 20 days notice. So we'll get started again. First, I'll ask Denise McCarl, Manager of Planning Services, to share a brief description of the application and to provide us with any public and agency comments that have been received to date.
Thank you, Your Worship. So very similar to the last application, this application is also subject to a consent, application B05-2022. So that application went through a number of issues that had to be satisfied, and this basically resulted in this condition being applied. I'm going to go through that in a little bit more detail with the GSCA comments that we received. The applicant had sought permission to essentially split the lot in half. So they had an 80-hectare parcel, just over 80 hectares, and proposed to sever 40 hectares, 40.49 hectares, and retained lands would then be 40.44 hectares. So this was a whole parcel on one of the original Crown Survey lots that was sought to be split in half. So through the application, it had been noted the lands are adjacent to some natural heritage features, including significant woodlands and a wetland feature. Originally, comments from the County and Conservation Authority recommended that an environmental impact study might be required to demonstrate that there would be no negative impacts to the features as a result of the severance, because it would allow new development to happen on the severed lands. So the Grey Sauble Conservation Authority, as a result of those comments, initially conducted a site visit and determined that the proposed building envelope that the applicant had identified was appropriate, and they suggested that a zoning amendment to apply a hold to the remainder of the property would work as a way of protecting those lands from impact from the development of the lands. So, for example, in this case, it was a kind of a square in the middle of the parcel that had already been cleared and didn't contain any significant features. So if a house were built in that middle section and the remainder of the lands had the hold applied, they were supportive. So the rezoning was applied as a condition of the severance as a means to ensure development would occur in that manner. And the Conservation Authority I will just go through the comments that they received because they are a little bit lengthy. So the historic Saugeen Métis had no objection or opposition. And the County of Grey noted that they had provided comments on the consent and that those still are relevant. So it's provided the adjacent environmental features are protected and that the instructive comments from the Conservation Authority are followed. They didn't have any further concerns. The GSCA comments supported the application, this application for zoning amendment, because they meet they're implementing the recommendations that they had provided through their letter of June 27th, 2022. They support the building envelope. Having reviewed the current proposal, they note it's in line with comments provided by their office. The development envelope on the severed lands is within 120 meters of adjacent lands that are currently mapped, significant woodland, fish habitat, potential significant wildlife habitat, a potential habitat of threatened and endangered species. But based on the site visit observations and historical aerial imagery, the site had been previously cleared for agricultural purposes and had been replanted with primarily coniferous trees. A section in the middle of the proposed severed parcel is identifiable in the current aerial image as not being a woodlot. They referred to that as the inner meadow, and it had been planted with ash trees, which were fairly juvenile and generally in poor health. And as such, they see it as a naturally regenerating meadow state. They note there is an access to the meadow from the Storybook Park Road that's already been identified. And so they're an opinion that the development could proceed within this proposed development envelope, the building envelope, without any negative impact to the adjacent natural heritage features. So they were supportive of this proposal of the zoning amendment. No comments were received from the public. And that ends all the comments that we've received. So the lands are split, designated and split zones. So they have agriculture, rural, and environmental protection. So the severed lands are entirely rural and environmental protection, and the agriculture lands and the EP, the rest of the EP are on the retained.
Thank you very much. And I understand the applicant is attending virtually to speak to their application. So I'll now call upon the applicant, Katie Gleiser, to share anything they wish to about the application.
Hello, everyone. Thank you so much for considering my application. I have no further comments, but I'm certainly here to answer any you have.
Sorry, I just missed your last words there.
Oh, I mentioned I'm happy to answer questions you have.
Sure. Okay. Do you want to stay on the line and we'll open it to council, because I don't believe we have anyone else with an interest in it. Questions from council for Ms. Gleiser? It looks like you're in good shape here with no questions at all, so that's fine. Thank you. Thank you very much for attending.
Thank you very much.
So, are there any points that there being no discussion? I don't think you have anything to recap, Denise, really.
Thank you, Your Worship. So no, we didn't expect there to be any real concerns. I did have a couple of phone calls, and when people understood what was proposed, they didn't have any interest in writing comments or attending. So we expect that both of these will come back fairly quickly for a report. Because of the minor nature that they are. So I will bring that forward into a subsequent meeting.
Thank you very much. I'm going to pass on calling Ms. Gleiser back and just close by saying that one, staff is satisfied that they have all necessary information needed to provide a recommendation on the applications. A detailed planning report will be brought back to council to assist in our decision making. And if you would like to receive mail notice of the future decision on the file, please provide your contact information to the Planning Services Division by email at planning@meaford.ca. I believe that brings us to the end of our agenda for this evening, and I'll adjourn it. Thank you.